Wow, that was fun. Welcome to Basic Estate and LLC Planning, Fun with Dick and Jane. And back in my day, the Dick and Jane series was an important reading book complete with the dog Spot, who was definitely smarter than Dick, Jane, or the authors. Let me warn you here that today's presentation will be 1 hour, but it will seem much longer. If you are a certified public accountant, then you have our sympathy, but you will get credit. There will be 4 polling questions. Make sure that you answer all of them in the order that they are presented. Let me warn you that the presenter here, Alan Gassman, is not very good, not very smart, and actually is himself a puppet that I am controlling. When he gets here, I'll pretend he's in charge, but he definitely isn't. And if you have any questions, you can ask them, but the answers may be wrong. So thank you very much and enjoy the show, if you can call it that. Oh, okay, here we are. Are you ready? No, we're not ready. We're waiting for people to get here. Well, it looks like we have a lot of people here. Oh, I don't see anyone. Okay, go ahead and get started, Alan. I hope this one's better than the last one. Yeah, I do too. I do too. And give me a hand. Okay, I gave you a hand, see? Okay, thank you very much. Welcome to the Basic Estate and LLC Planning Fun with Dick and Jane. You should be able to see my screen, and I see that everything's working. I welcome your questions, comments, suggestions, and advice on how to get rid of an obnoxious puppet. Please note that this is a 1 hour presentation. It will seem longer, as the puppet said. It does qualify for continuing education credit for CPAs if you logged on through the CPA Academy. If you are a CPA and you did not log on through CPA Academy, then this will be a complete waste of your time as far as getting credit, but hopefully it will be worthwhile anyway. But what I'm really looking forward to is at noon, we are going to bring on George Greer, and George Greer was a very important judge. He's now a very important person. He was also a county commissioner and a practicing lawyer and one of my personal heroes. So we'll be learning more about George Greer at noon. So again, CPA Academy, if you logged in through the webinar of CPA Academy, you're going to get an hour, and the polling questions will mean a lot to you. If you logged in through our website, no CPA credit, and you can ignore the polling questions. You could take a break during the polling questions if you're listening at all. If you want to ask a question, then all you have to do is click on the inverted pyramid there, or the down arrow. I guess that means it's not a good show, and ask your question by typing the question in, and I will either answer it or pretend not to see it, depending upon what works best for me. Later on today, this will be posted to our free YouTube library. I hope you watch many, many times, because I think I get paid like half a cent every time you click on this. So if you could click like 1,000 times, I might get $50 or $5, maybe 50 cents. I'm not really sure, but there are a lot of good videos here, primarily the one on ventriloquism, which by a ventriloquist who's even better than I am. If you are a Florida Bar tax section member, please join me for this free presentation for tax section members, Hot Topics and Best Strategies for Estate Tax Planning, Part 2, that's French for 2, July 13, 2022, could be your lucky day. And then once you join the tax section, you can also see Part 1. Part 2 will be better, but they're both pretty darn good. So the first thing I want to mention is, if you want to get a good estate plan, make sure that somebody sweats the details. In other words, make sure that beyond just a will or a trust, that you follow up on beneficiary designations, ownership of life insurance policy, account titling, corporate paperwork, tax returns are consistent with what the lawyer did, And my idea for many of you, because there's a lot of successful people on this webinar, is appoint a project manager. Go ahead and delegate the estate planning. Have somebody else deal with the lawyer and the accountant, get it all queued up so you can show up when it's important and get it done, both before and after you hopefully sign your documents. So that's the concept of today. Whatever you've been procrastinating, including that estate plan, please appoint a project manager. Could be a puppet, could be a real person, whatever it is, get the thing done. And then I have a lot of definitions that we may come back to, we may not, but I'll let you know that they are here and that I plan to cover them during the presentation. But if you want to come back to the definitions later, you will have them on my slide deck. Certainly they are not every definition you would need, but there's a lot of definitions. What we are not going to talk much about today is estate tax planning. But if you are an estate tax planner, and I think we do have at least 200 or 300 estate tax planners on this live webinar, please make sure that you consider these 15 techniques for your clients. Most of us have 5 or 6 techniques we use, and we don't really think about all 15 of them. But we find that there are situations for many clients where you need one of all of these 15. And if you're not using all 15 of these at least once or twice a year, please consider our Florida Bar presentation or similar presentations. Another point I wanted to make for the wealthy, all 6 of you out there who happen to be wealthy, is the interest rates are going up, up, up. So in May, I could loan $10 million to my grandchild trust at 2.66% interest. In July, it's 3.22%. But if I sell an asset to the grandchild trust on a long-term note, I can still use the May rate as long as I do it before the end of July. The rates are going up, so let's go ahead and get these long-term debt into place. So this presentation was prepared by a lawyer named Valerie, who answered an ad to work for our law firm, and the ad was math major needed to work on spreadsheets. And I think most of the attendees know I am a spreadsheet-aholic, and I don't know how to make a spreadsheet. I just know how to make other people's make spreadsheets. So Valerie answered our ad. She came to work for our law firm. She enjoyed the spreadsheet so much that she went to law school. And then after she graduated law school, she went and worked for someone else, which I felt was very disloyal, but I'm very happy for her. So she prepared this presentation in her second year of law school, and I think she learned a lot doing it. And this is the story of Jane. Jane has a daughter named Sally, and Jane has a home, a brokerage account, a bank account, and an IRA. And the IRA is made payable to Sally. And as you can see, Sally is not an adult. She thinks she's an adult, but she is not an adult. So Jane would like her assets to go to Sally. And it's all good, isn't it? Because Jane knows that the state of Florida, if Jane is single, will make sure that if Jane dies, her assets will go to Sally. And Judge Greer, when he joins us at noon, if you ask him any questions about guardianship or probate, he'll know all about it because he was a guardianship and probate lawyer and judge for many years. So Jane goes to a financial planner, and there are many financial planners here on this talk. So thank you for being financial planners, and learns that Sally, who is 16, you see how old she looks, 16, should not be the direct beneficiary of Sally's IRA. And Jane needs a will, because if this estate plan stands and Jane dies, then the judge will have to appoint a guardian. The judge may not know who the guardian will be if Jane hasn't left any instructions. and the guardian will then have to probate Jane's estate, which will cost some money. And once the estate is probated, what's left after the probate fees, which may be $3,000 to $5,000, maybe less than that, will go to the guardian, and the guardian will spend that money on Sally. And then when Sally is 18 in most states, Sally will receive what's left and spend it any way she wants. So that's probably not what Jane would want to have happen. So Jane's financial advisor says at least set up a last will and testament with a testamentary trust provision. So a last will, let me go back to probate. When a person dies with assets in their sole name, in order to get the assets out of their name into the name of their beneficiaries, you have to go to the probate judge. You have to prove to the probate judge that the person died and that the person had a will or no will, and that all of the person's taxes are getting paid, and that all of their debts are getting paid, and that the right people named in the will or under the Florida statute or whatever statute you're in are going to receive everything, that the personal representative or executor is bonded by an insurance company, so if anything's stolen, it gets paid for. There's a lot of red tape there. It's necessary red tape to protect the community, but it is red tape. So Jane can establish a will, and the will says that Jane wants all of the assets to go to a trust for Sally. She wants her best friend Gertrude, or the local bank, or her lawyer or her accountant to be the trustee for Sally, and to do what's right for Sally up to age 40, not age 18, age 40, so that Sally is well cared for. And if Sally turns out to be a drug addict or married to a drug addict or just wouldn't go to college unless if she had the easy money, that doesn't happen. So that's a testamentary trust. But when Jane dies, the assets still have to be probated. Even though the will says on my death, this will go to trust, it still has to be probated. Now, she could make her IRA and maybe her brokerage account and bank account payable by beneficiary designation to the trust established under her will, and they would avoid probate. And she could do a ladybird deed so that her home would automatically pass to the testamentary trust on death. So a will might cost $300 to $400, whereas a revocable trust, which we'll be talking about later, can easily cost $1,000 or $2,000. So this is the estate plan that Jane may have, and you notice in the slides that everyone is happy. So Jane goes to her banker, her very friendly banker. And by the way, Brittany, do you know where my sound effects box is? I'm missing it. So anyway, I have great sound effects coming up. Just wait. So Jane goes to the bank and has the pay on death account payable not to Sally, but to the will with the testamentary trust. And everybody is happy. So that is what Jane initially has. But later, Jane saves a lot of money, and she can afford a revocable trust. So she puts the assets in the Jane Smith Revocable Trust. Jane is the trustee of the trust. Jane is the beneficiary of the trust, along with Sally. So under the revocable trust rules, Jane enters into an agreement with herself. Now, it's not like your diet or other situations where you make an agreement with yourself and you break it. You don't have to break the trust agreement, because the trust agreement says as long as Jane is alive and well, she can do anything she wants. She's the grantor, she's the beneficiary, she's the trustee. But on Jane's death, her friend Gertrude can become the successor trustee, and immediately have control of the home, the bank account, and be the beneficiary of the IRA and hold those assets for Sally without having anything go through probate. And in addition, if Jane becomes incapacitated, the chances are she will not need a guardianship, at least not for her assets that are under the revocable trust. Now, before you do this at home, before you call LegalZoom and do this at home, make sure that it is something that you need and that you're doing. And I don't recommend LegalZoom. I mention it. Anytime that we see someone make their own estate plan, we go to the F. Lee Bailey quote, anyone who does his own legal work has a fool for a client. F. Lee Bailey wrote that in a book in 1971 called The Defense Never Rests, which I read in middle school. And since then, I've seen a lot of lawyers who did their own estate plan and they didn't turn out so good. And maybe when George Greer comes on at noon in 44 short minutes, he'll tell us a story or two, and one of them may actually be true. So again, now Jane has the revocable trust. She puts her brokerage account in the revocable trust. She puts her CD in the revocable trust. And I found the sound machine so I can give you the first round of applause for what Jane has done. Thank you very much for that beautiful round of applause. And now we'll go to our first polling question, which has nothing to do with Matt Polling, who is one of my favorite real estate lawyers in Tampa. So this is polling question number 1. Would you prefer to receive for free as a PDF one of the 4 books that I've authored or co-authored? Number 1, Grow Your Medical Practice. Number 2, The Florida Physician's Guide to Creditor Protection. Number 3, C, 8 Steps to a Successful Florida Estate Plan. Or D, Florida Federal Asset Protection Law. If you type in what you would like to have, or if you answer the polling question as a normal polling question, except if you're Matt Polling, please don't answer it, then we'll go to the next slide. So Brittany, let me know when we're ready to go to the next slide. In the meantime, we'll see, did anyone like my last joke? Oh, they liked it. It's great to have a participating audience. Now, a lot of people ask us, will the trust for the daughter, Sally, be a special needs trust? And the answer is, what is a special needs trust? That is a trust that basically says the trustee will give Sally anything that Sally needs that will not disqualify Sally from being able to be on Medicaid or other public support. So if Sally has a debilitating situation, then you may need a special lawyer who is in the special needs area, and a lot of times elder lawyers are in that area, and they can draft that trust for you, or a sophisticated estate planning lawyer can draft the trust. Our trust documents say that if any beneficiary has special needs, then the trust for them will become a special needs trust. So sometimes in some lawyers' documents, that's automatic. Some lawyers do special drafting. It can all vary. Let me also mention that Sally should give Gertrude or someone else she trusts a durable power of attorney, but don't go buy it in the form store, because at least for Florida, a durable power of attorney cannot be a springing power. It has to be live when you sign it. It can't say Gertrude will become my agent and only be able to serve if I'm incapacitated, or it will have no power whatsoever in Florida and some other states. And then in Florida, it has to enumerate everything that the person can do, and you have to initial in 7 different places in order to get Kentucky Fried Chicken with 11 herbs and spices. So be careful out there. That was just a detour. Now, here's the next part of the estate plan. Jane starts a flea market business She makes sweaters for dogs and they have fleas, so that's why it's a flea market business. And she wants to get this business set up, and she starts it as a sole proprietorship, which means she owns the business and she runs the business on her own. And if anyone gets hurt by a dog sweater, because you know people trip and fall on dog sweaters all the time, then she will personally get sued. And that will be very sad. So don't let that happen. Don't let the bombs go off. What's better is that Jane will set up an LLC, and it will be a single member LLC owned by Jane. It will limit liability to Jane if somebody slips on a dog sweater, if Jane was not personally liable, or product liability if the sweater hurts somebody. And nevertheless, it is disregarded for income tax purposes. So while we recommend that it have a taxpayer identification number, the CPA will be able to tell the IRS that this creatively named LLC, Sweaters for Dogs LLC, is disregarded, and it will go on Jane's personal form 1040, Schedule C. If it is a rental activity, it will go on Schedule E, which is the grade I made in chemistry in 1976. Or if it is a farm, then it will go on Schedule F. But it all goes on the Form 1040, even though it does block liability. So Jane's CPA, though, and there's a lot of CPAs on this webinar, and we welcome you. And CPA stands for Certified Public Accountant, not Certified Pain in the Donkey. But the CPA may recommend that Jane make an S election. Now, it has nothing to do with S&M. It is an S election under subchapter S of the Internal Revenue Code, beginning at section 1361, which I recommend you read tonight if you cannot sleep. If Jane recommends the S election, then the income and deductions will still flow through, but the dividend income will avoid employment tax and will avoid the section 1411 Medicare tax. So if you want to dial 411 and avoid the Medicare tax, call a CPA or a qualified accountant and see if Jane should make an S election. I won't get into too much more detail other than to mention that before Internal Revenue Code section 199A came out, it was a no-brainer for most people to have S corporations. But now, to get your 20% deduction under section 199A, if you're an S corporation, you've got to pay a salary, and you have to pay a salary under an S corporation anyway. It's a long story for high earners. Talk to a qualified accountant. If you're an Uber driver, or you have a flea market business, or you make $10 million in your business, should you have an S corporation? The answer is often yes, but please talk to your accountant. Now, Jane does not want the company taken away from her if she is in a car accident. So she may put a friend as a co-owner of the LLC. And now in most states, if Jane gets sued, the creditor cannot reach into the LLC because of the charging order statute. But once Jane puts a friend on the LLC, number one, you may lose a friend because that's how business goes. But number two, the LLC will now have to be taxed as a partnership and file a Form 1065, or an S corporation, or a C corporation. So let me find the next polling question, because I don't want to miss out on polling questions, and then I'll go back. To change the subject for a minute, the federal estate tax exemption, which is true. By the way, the answer is D, all of the above. And once 95% of you have put down D, then we'll go to the delicious next slide. But here is the question, which is true? Right now, the estate tax exemption is $12,060,000. The gift tax exemption is $12,060,000. The annual gift tax exclusion is $16,000 per person per year. I think that'll be $17,000 next year with inflation. Or D, all of the above. So the drum will roll. And yes, the answer is D. You win a Winnebago. All right, so where were we? Jane, back and forth with Jane. So let's get a little bit more sophisticated. Jane puts away a lot of money because so many buy dog sweaters. And she sets up a family LLC or a family limited partnership. And she sets up an irrevocable trust for Sally and Sally's future children. The trust is disregarded for income tax purposes because Jane retains the right to replace trust assets with assets of equal value. Therefore, because the trust is disregarded for income tax purposes and Jane is a person, the limited partnership is disregarded for income tax purposes and all of its income goes on Jane's Form 1040 tax return, as if there was no limited partnership. So a lot of you involved with banks and brokerage firms have to explain over and over again that you can avoid having to put income from a limited partnership or an LLC onto a partnership tax return by having it owned by disregarded entities. So it's actually less expensive for Jane to set up an irrevocable trust, even though that may cost a couple $1,000s, so she doesn't have to do an annual tax return for the limited partnership. And now if somebody gets a judgment against Jane, in most states, they will not be able to reach into the partnership, such as if a dog sweater that Jane knitted hurts them. So be careful if you buy dog sweaters because they could hurt you. And then Jane gets involved with a rental property. And Jane puts the rental property in a separate LLC, but you would not want the dog sweater company to own the LLC. Because then if somebody sues the dog sweater company, they could get the LLC company. So this is a don't do this. And the next time you see this slide, there will be a big red arrow that says, don't do this. Now, I'll mention for the professionals that you can use this chart to help your clients decide whether they should use a partnership or an S Corp. So when you set up an LLC, you can decide if that LLC is going to be taxed as a partnership, an S Corp, disregarded, or a C Corp. And when you're putting real estate into an LLC, there's 6 good reasons that you want the LLC to be a partnership, but 1 reason you don't. And then there's 6 good reasons that you don't want it to be an S Corp, but 1 reason that you do. So I can't give you a straight answer because I just had retina surgery and I've got a wavy line. But other than that, if you think that your client may become insolvent and they're not insolvent yet, and that the real estate will be upside down, then you want an S corporation, because income from discharge of indebtedness when the property gets repossessed or you give the deed in lieu will stop at the S Corp level. Otherwise, for many reasons, you want a partnership. And then I have a chart here on page 63 that the professionals can use for their clients. If you are not a professional estate planner, please do not try to use this slide. You could hurt yourself if you try to do this at home. Speaking of hurting yourself at home, we mentioned to Jane, please do not form your own LLC. Please do not let your accountant form your LLC. Why? Because we review a lot of LLCs every month, and there is a very high error rate. And I'll tell you where those errors are. Number 1, if you live in a tenancy by the entirety state, where the creditors of one spouse cannot touch a joint asset if it is properly titled. There is special language that you need in the LLC operating agreement to have it qualify as tenants by the entireties. It's complicated. I don't need to explain it today, but I can tell you that we see a lot of operating agreements prepared by very good lawyers that accidentally cause loss of tenancy by the entireties. Worse than that, statistically, is the number of operating agreements we see that would cause loss of the S election if the IRS were to audit the client and look at the operating agreement because of the second class of stock requirements. So now Marcia has told me many times that I have no class, but I have not, at least I have not flunked the second class of stock requirement. So you can fly second class, but do not ignore the second class of stock requirement in your LLC operating agreement, because if you lose your S election, then you're considered to be a C corporation and your income will be double taxed going back probably 6 years. So not good things. So I do caution you accountants, you're my friends, I love you, or at least I'll pretend to. But when you form LLCs for clients and lead them to believe that they do not need an operating agreement or that they can just get an operating agreement off of the internet, you may have done a huge harm. So you could, not buy paper and not eat expensive food and eat cans of tuna instead, but please get an operating agreement drafted by a competent lawyer who at least has some malpractice insurance, because that's where we see a lot of mistakes. Now, these charts have nothing to do with our presentation today. Then we get into the homestead. And in Florida, the homestead can be very tricky. Because here's what thing I failed to mention. I forgot to mention it, and lawyers in Florida forget this all the time. If you have real estate in Florida and you die with a minor child and the real estate in your sole name, then on your death, the real estate does not pass by your will, it does not pass by your trust, it passes by operation of law under our archaic Florida Constitution, which means that this 16-year-old who looks like she's 8 is going to own the home when Sally dies. I'm sorry, when Jane dies. So if I have 6 children and 1 is a child and 5 are adults, and I'm not married and I own the real estate and I die, then each of my 6 children gets the property directly by operation of law. It doesn't matter whether my will or trust says something different. If I'm married and I own the property, then my spouse gets a life estate or 50% ownership based upon my spouse's election, and then the remainder is going to go to those children or the other 50%, depending upon what my spouse elects. I don't expect you to follow what I just said, but I would hope that that explains why you want a lawyer to work on your estate plan. Probably not one as goofy as I am, but this stuff does get tricky. And speaking of tricky, let's talk about love and relationship. If you read Fun with Dick and Jane, you know about Spot. So Jane meets Richard, see Richard run, Richard run. Jane catches Richard. Jane better get a prenuptial agreement before the wedding bells start to ring. So prenuptial agreements in, I believe, all 50 states, the ones I've checked out, will hold up to a certain degree and should be mentioned on the second date. The first date, I don't think I would mention it. The second date, I would at least mention it while you're making eye contact to see how the other person responds to determine whether you need one. Now, this is not for first marriages necessarily, except possibly to protect an inheritance. But second and third marriages, I would definitely make sure you mention that on, during the second date, before very much alcohol is consumed. So Richard has actually 20 million of assets, no children. He's never been married. He's really nice, and he completely trusts Jane and would like to put all of his assets in joint names. Yes, Richard is an idiot. So they get married. Life is going really well. And now Richard starts putting assets in the joint account and into Jane's account. And Jane updates her will so that she will reckon with Florida's law, which requires her to leave at least 30% of her estate to Richard, unless Richard signs away the Florida elective share. And it's very similar to all of the other states, but every state is different. Find a lawyer in that state to help you. If you're in California, find 2 lawyers in that state to help you. So Richard has a good income stream. Jane's concerned that if he dies, she'll lose the standard of living she has become accustomed to during the 12-week marriage. These have been 12 great weeks. She now is seeing an analyst. She's dependent on sleeping pills. She drives the Porsche 911. She goes to the country club every day, and everyone at Nordstrom's likes her a lot, but does not want her to work there. The lesson being that people become accustomed to a higher standard of living faster than you may think. So one advice that I have for Jane is not to spoil Sally. A lot of clients hit it rich, and then they live in a high standard of living. They don't leave enough for their children. Their children have a much lower standard of living and are depressed about it. So there's a great video on YouTube by Professor Sut Jolly of the University of Michigan called Advertising and the End of the World, and why you can't be happy unless you have all these toys and all this contact. It's a bunch of hogwash. Even Listerine is too expensive, by the way, speaking of hogwash, but that's my 2 cents. So now we have to buy a $5 million life insurance policy on Richard so that Jane can maintain her standard of living. Richard can establish an irrevocable trust for Jane and Sally. He can put a $5 million life insurance policy in it, and it can benefit Jane and Sally while Richard's alive. But if Jane divorces Richard, then she is out of the trust. And that trust is called an ILIT, an irrevocable life insurance trust, and it's also known as a spousal limited access trust. So what is a spousal limited access trust? It's called a SLAT. It is all of the above for those of you who are doing the polling question. And a spousal limited access trust, often used to avoid estate tax. It is not a spousal limited unitrust, which is something else, also known as a SLUT. And D, the correct answer, is all of the above. And I apologize for the terrible humor here. That one really bombed. And the sound effects aren't very good either. Well, that one's for Halloween. Okay, so we talked about the life insurance trust. Now we can talk about asset protection and some more sophisticated planning. But first, let me see if there's any questions. Okay, the first question is, when will this be over? When will Judge Greer start? Jesse liked the slut joke. Okay, what would you put in place to avoid Florida homestead law for passing real estate based on operation of law? Thank you, Robert. What we'll do most often, first of all, is just mortgage the homestead to the hilt. You could make a promissory note secured by a mortgage payable to an LLC. or maybe even payable to the revocable trust. So what the children receive is a leveraged homestead, or put the homestead in an LLC and then do a 99-year lease between the LLC and the client that terminates on the client's death. And that way, when the client dies, there's no homestead right, I believe. We'll ask Judge Greer when he gets started with us in 20 short minutes, probably 20 long minutes for those of you attending. And that would be able to, that way you can keep your homestead exemption under Florida law, which is really important because then they can't raise your exemption by more than 3% a year as far as value. Okay, James says, are FLP still being used for general partner control? I recently had an attorney tell me you can do the same thing for an LLC. I will admit that this slide deck is pretty old and that we were using FLPs back then. Now we will normally use an LLC for this, but sometimes we will use a limited partnership depending upon what state it is, but not relating up to the state of confusion. Okay, Catherine says, is it advisable to create LLCs for multiple rental properties? And the answer is, it is for two reasons. The first reason is, if one property gets in a lawsuit, you won't lose the other property. And the second reason is, one of my sound effects, yes, we can charge more for multiple LLCs. An alternative is that you can put 3 properties, for example, in an LLC, and then have that LLC owe money to the client in a note and mortgage, preferably recorded, but not necessarily recorded. And then if another creditor comes along because somebody slips on that banana peel that you accidentally left on the step, by the way, please don't leave banana peels on the step. But if you do, then the insurance hopefully covers it. You hopefully have a lot of insurance. But if that doesn't cover it, then when that creditor forces a sale of the 3 properties, the first money will be what's owed on the promissory note going to the client. And that is called equity stripping. So those of you into nudity, remember the equity stripping. Okay, is Florida a tenancy by the entirety state? Yes, and so is Delaware, and so is Wyoming. And there's others, some of them, like Pennsylvania and Tennessee, have tenancy by the entireties for some things, but not others. And then in Hollywood, you have Tennessee tuxedo, but not tenancy by the entireties. So those are some of the questions. And then Lee Gross, thank you very much. Is there asset protection when using a single member LLC? It depends what state you're in. If you're in Nevis and St. Kitts in the Caribbean, it's going to be protected by that law. But under most states, you need a multiple member LLC. And we go further than that. We also have voting and non-voting. So for example, I own 97% of the LLC, but only half of 1% voting, 96.5% non-voting, and my daughter owns 0.5% voting, 2.5% non-voting. You get a judgment against me. Even if I don't have charging order protection, you cannot take over control of the LLC. Now, a lot of people, when they see the NV for non-voting on our chart, they think that that means North Virginia, but it's not North Virginia, it is non-voting. So do think about your creditor protection. Jane needed a lot of insurance. Now, Jane was able to get married, and if she had $1 million worth of assets and her spouse had $1 million worth of assets, they could put them together into tenancy by the entireties. And then if Jane gets sued, they can't be touched unless they have a judgment against her husband also. And her husband had nothing to do with the sweaters for dogs. He modeled them, but he wasn't integrally involved with them. So then if they got divorced, he would get half back, Jane would get half back. Actually, the lawyers would get half, he would get 25%, and Jane would get 25%. Now, number 9, which is a great song from the White Album by John Lennon, is the Uniform Transfer to Minors Act. Now, you can put assets not in the child's name, but it would be Jane as custodian for Sally under the Uniform Transfer for Minors Act. But I call that the Uniform Transfer for Creditors Act, because under the state law in most states, including Florida, if Sally is in a car accident, then the creditor can reach into the Uniform Transfer for Minors Act account. But a creditor in most states cannot reach into a 529 college savings plan. So Jane would be better off putting the extra savings into the 529 college savings plan. And now let me step on the toes of a few financial planners. You take a client who has a $2 million stock and bond portfolio, and you tell that client your child is age 1. If you want to have $250,000 for college, start funding this much a year for the next 20 years into a 529 plan. I say no, boo, hiss. The better answer is fund that 529 college savings plan with $150,000 today. Why is that? Number 1, all the growth is going to be tax-free. Number 2, you're going to have $150,000 of assets creditor protected. So that's the thought on that. Now, the 529 college savings plan is like a mutual fund. It grows with the stock market, or it can be put in bonds or a combination. That's different than prepaying college tuition. And if you're going to prepay state school tuition, then start taking your child to football games, basketball games, cheerleader things, or summer camps at that school if you want them to go to a state school. Because when they go to the fancy high school, then the high school guidance counselor is going to tell them not to go to the state school. So you got to start that probably at age 3. So let me go to the next polling question so that these CPAs can be happy. Who have you received the most estate planning advice from? A, an estate planning lawyer. B, a lawyer who only does asset protection work all over the country. She must be a great lawyer if all she does is go from city to city and sell asset protection. C, LegalZoom, which may be fine if you have a lawyer review it when you're done and fix it. D, an independent salesperson who has financial products that provide everything needed. Or E, a person someone knows who lives in an island country. So the answer, in my opinion, for most people is A. So go ahead and put down your favorite answer. And then with a drum roll, we will announce the official answer. Hopefully A, but maybe not. It's up to you. So let's talk about where Jane might be if she were a successful physician. Now, of course, successful physicians make significantly less money than people who sell dog sweaters. There's the joke about the plumber. The guy calls a plumber. Plumber comes over, and the guy says, "My toilet's broken." The plumber does this, does that, hands the guy a bill for $275. And the guy says, $275? I'm a neurosurgeon. I don't make $275 for a consult that short. And the plumber goes, I know. When I was a neurosurgeon, I didn't make that kind of money either. So just goes to show you. Anyway, you've got a single person, and they have a revocable trust. The revocable trust does not help the creditor protection at all, but it helps the avoidance of probate, and it helps your lawyer continue to make a decent living, hopefully. So Then, oops, the sound effect. All right. Then the person individually owns the IRA, the 401k, annuity contracts, which are creditor proof in most states, but also turn capital gains tax into ordinary income and may generate large commissions for advisors, may distort their judgment, may cost consumers too much, may make financial promises that can't be kept. You can tell I'm not crazy about all annuities. Then there's life insurance, and then wage accounts. So for creditor protection purposes, in many states, you would leave these assets outside of the living trust. And the IRA and the 401k, pension, 403b, they can't go into a living trust until you die. And it's not worth dying just to get that to happen. Now, the living trust can be drafted so that it is what we call a stretch trust. That does not mean that it's going to own a Pilates machine, although you could put your Pilates machine in the living trust. The stretch trust is a trust where when it receives the IRA or the 401k, if it's for the surviving spouse or someone who is disabled, chronically ill, or no more than 10 years younger than the plan participant who died, then it may stretch for the lifetime of the beneficiary if you have the right language in the living trust. Otherwise, it will stretch for 10 years for the beneficiaries if you have the right language in the living trust. If you have the wrong language in the living trust, then it will have to come out within 5 years. And that is under what we call the Secure Act, SECURE. I won't tell you what it stands for because it doesn't matter and I don't remember. But those regulations are going to be revised this year based upon proposed regulations. And if you would like to beta read our book on this, I'll be glad to send you it this weekend. Just send me an email that says beta read, BETAREAD. Has nothing to do with the fish. I promise not to send you a fish. I'll send you a Word version of our IRA book. And if you promise to give me at least one comment. Any comment you like this is too thick, or I don't like the typeface, or I actually read a chapter and found a problem. Okay, now Jane cannot own the professional practice directly under the living trust because under state law, the professional practice has to be owned by her individually. So we need to fix this slide, Brittany. But on death, the professional practice can go into the living trust by signing a conditional assignment of stock. So I have assigned my stock in Gassman, Crotty, and Denicolo, PA, to my revocable living trust so that in the event of my death, Marcia can transfer the stock into the revocable trust for an instant in time and then sell it as trustee to my partners for so little money because it's worth so little, but at least she won't have to put it through probate because my partners would charge her way too much for that. But that conditional assignment of stock, if you're a CPA, and there's a lot of CPAs here, you might want to consider that for you and your clients. It's a simple one-page document. So then Jane's got the medical building subject to a mortgage. So for creditor protection purposes, we're going to give the bank a big mortgage on the medical building, and then we're going to cross-collateralize it with the professional practice company assets, furniture, equipment, and accounts receivable. So now when Jane gets sued for committing malpractice, maybe she left a dog sweater in somebody during an operation, then, or maybe a button, let's say a button, then when they get the big malpractice judgment against her practice, she'll be able to put the practice into bankruptcy, and she'll be able to buy the furniture, equipment, and accounts receivable for what they're worth, not much more. She has no employment agreement with the practice. She has no non-compete. Please make sure of that. And then the proceeds from the sale and the proceeds from any collection of accounts receivable go and pay the bank to reduce her mortgage. And then if they get a judgment against her personally, they can only get a charging order against her 97% of the LLC. And under the charging order statute, it has nothing, there's no voltage, it has nothing to do with her Tesla. you could put a Tesla in an LLC and then the creditor can only get a charging order. That's kind of cute, isn't it? I have to write that down for a future webinar page. But anyway, when someone gets a judgment against her, the judge will award a charging order against the LLC, but not allow the creditor to reach into the LLC or receive anything until Jane withdraws from the LLC something, or if Jane uses an LLC asset or makes a distribution to the gifting trust, then the judge can, according to a recent case in Nevada or Utah, at least, force the LLC to give money to the creditor because the creditor allowed Jane to benefit from the LLC. So she would have to continue paying long-term rent. So what Jane may want to do is put her 97% of the LLC into an offshore or Nevada asset protection trust, and then she could write off her next trip to Las Vegas and her next trip to Belize. While she's in Belize, she may want to look around and see the most beautiful barrier reef in the Eastern Hemisphere, or of course in Nevada, she could see the Strip, which she could do her equity stripping in Nevada when she visits the Nevada Asset Protection Trust firm or the trustee there, who are also very close to the Strip. Now, you could put your S corporation stock under a Nevada Asset Protection Trust, but not under an offshore asset protection trust. So let me go back to questions and answers here, see if anyone is still awake. Okay, Nancy, thank you very much for this. Did you say that the new trust avoids probate while the testamentary trust goes through probate? Both are reported on the 706. Okay, that's really good, Nancy, and I'm sorry that I forgot to mention federal estate tax, one of my favorite topics. Anything that was owned in Jane's own name or under her revocable trust will be subject to federal estate tax if Jane's estate exceeds $12,060,000. That's coming down to half inflation adjusted in 2026, unless you get 60 senators in the House and the president to agree to the contrary. It'll be very interesting to see if that happens before or after 2026. So probate, on the other hand, will happen to anything in Jane's personal name, even if she has a will, unless there is a pay on death account. And yes, so all those assets are reported on the Form 706 estate tax return. Okay, Matthew's best friend is a doctor. I'm glad to hear that, Matthew. A lot of people don't have a best friend. So thank you for that. Okay, any other questions here? All right. Is there an address to order the dog sweaters? My wife buys them by the dozen. Yes, send $1,000 made payable to my law firm, and I will send you 5 dog sweaters. And I'll personally wear them for a week before I send them to you, if you like. And I do not have fleas. Okay, those who lie down with dogs no longer have fleas if the dog is treated by a qualified veterinarian, but do not lie down with a dog anyway. Okay, Jacqueline met Judge Greer years ago at a Pinellas County Estate Planning Council and thinks that he is absolutely wonderful and more important than Ringo Starr. And I agree with that. Judge George Greer probably is more important than Ringo Starr. And I'm hoping that George Greer's camera will be working. Otherwise, Brittany will have to go to his house and turn his camera on, which will cause a 10-minute delay. Okay, let me see here. I have 1 minute left before the George Greer story begins. I want to mention to you that if you are a CPA, you are getting credit from CPA Academy. Thank you very much, cpaacademy.org. Anyone can join CPA Academy, even me, and they do a very nice job on the continuing education credit, and there's no charge. So speaking of getting a charge out of things, let me go to the George Greer slide. Those of you who are CPAs are not going to get credit for the next hour, but I hope it's worth it if you stick around. George Greer was born in Brooklyn, New York, like so many important Americans, and moved to Dunedin, Florida, like so few important Americans. He attended, just figured that out. All right, well, that was Hamden Baskin, who, if you read his lips, he said that George Greer was and still is an outstanding judge and professional. And George, your two main claims to fame, which are well-deserved but not really who you are, is the Terry Schiavo case and that you were Jim Morrison's roommate in college. Which experience would you like to start with before we get into things more important, such as professionalism?
Well, let's start with the oldest one. That was one semester in the 1962-63 school year, which is also the year that Animal House says it's filmed in. If you'll read the scrolling underneath the two fellows walk into the frat house at the start of the movie, it says 1962. There were six of us. We rented a 3-bedroom, bath and a half home about a mile from campus. In the biography, no one here gets out alive. There is a generic reference to me on about page 32 or so. It says he lived with 5 male housemates, 2 of whom he'd known before, and the other 3 were housemates of convenience. And so I was a housemate of convenience. I didn't know him until I met him when we moved in. We threw him out after 1 semester because it was far too much drama. And that's the last I ever saw of him.
Can you tell us a little bit about the drama?
Well, he'd go out at night, get half smashed. I mean, his drug of choice was tequila. And he'd go up to these nice, good-looking gals who were standing there with this upright a man of freezer that played right tackle and start using the F word long before it was fashionable. And we'd have to drag him out of there before he was killed. And then Halloween night, he stood at the door closed, stark naked, with a mouthful of lighter fluid. And some little child would knock on the door. He'd open it, standing there naked, light a lighter and blow the lighter fluid across the flame, and looked like a dragon with fire breathing. And the poor little kid had run screaming to his parents on the sidewalk. And then he just kind of liked to play mind games. And so we just said, enough's enough. You're out of here.
Was he playing any musical instruments or singing or doing poetry? You remember any of that?
He was quite the mimic. He would listen for hours writing to his radio and writing stuff down in a notebook, small notebook. But during football games, he would get out on the upper deck, the thing over the lower deck, and do Brother Dave Garner and some of the other comedians of that era. And the fans loved it because it was a break from halftime.
Wow. Are you in touch with any of the other roommates?
Mostly with the enrolled agent who moved maybe 2 or 3 years ago to California. And he'd actually been, he was with the IRS in Florida, and he was in Miami when Morrison's trial for obscenity went on. And he even sat a day in the trial, and they went out to dinner afterwards. And he said Morrison was in his drug of choice. He had a whole bottle of tequila. There's one other that was in my high school class. I see him at reunions, and that's about it. His younger brother, those are the 2 he'd known before. His younger brother I haven't talked to in probably 15 or 18 years. And then there's the other one nobody ever found. He was from Fort Myers.
And did you ever meet his father? I guess his father was in the military, right? His father was a high-ranking military.
His dad was an admiral, and no, I never met him.
Yeah.
I've seen some videos with his father talking about his son long after his son died, of course, and I think his dad had revisionist history because they were not close at all. But he speaks lovingly of his son.
Yeah, royalties will do that sometimes.
Sometimes they will.
So George, I first met you when you were a county commissioner in Pinellas County. I remember a mutual friend, Henry Mazes, back in, I think, 1985 or 1986 or 1987, brought me to you and said, here is the nicest guy and a completely honest office holder. And how did you enjoy being on that commission?
Alan, I loved it. We're a commission of 5. All of them I knew prior because I did zoning and land use. And we got along great. We accomplished a lot of wonderful things. The real problem was I couldn't afford to be nothing but a county commissioner. So even though that was a full-time job, I had to run a law practice too.
Yeah, I remember my law office economics professor said, the best thing to do is run for political office, but make sure you lose, because it's great publicity and then you don't have to serve.
Well, I actually ran because of the stadium. I was opposed to it, and the guy I ran against, who happened to be the only person of the other party on the commission at the time, was a swing vote for it. And so I ran, and that was the issue. And I wasn't interested in building my law practice. I was interested in winning a race.
Yeah, well, you care more about other people than you do yourself, which has been your trademark. But then, just for history's sake, Pinellas County and St. Petersburg did build a stadium before they had a baseball team to the tune of, what was it, $80 million in the 90s? And then, thank heaven, got a baseball team.
No, Alan, I think the original agreement, the interlocal agreement between the county and the city, which was before I got elected, I think it was like 60 some odd million was the number they talked about. When it came time to get ready to build it, it had doubled or more than doubled. And that's the reason that I gave my very first meeting, a lawyer you and I both know and think the world of, who's now in California, retired. He drafted my motion, which basically got us out of the interlocal agreement. And it really was that what was on the table now was not what we agreed to. So it's different. So we don't want to be there. And my motion passed 3-2. The city filed suit, and ultimately a St. Petersburg judge hometowned us, ruled for the city of St. Pete.
So George, let's go. What I want to do is I want to cover the Shivo case, and we have a few hundred people on, and I'll bet most of them don't remember or know what the Shivo case was. So if you could, give a nice description of what that case was and what that experience was like, and then we're going to get into your role as a mediator and your thoughts about avoiding disputes before they happen or resolving disputes after they happen. Because as a judge, you were very effective at getting people to settle their matters before they ever got close to a trial. And you were very effective as a judge at letting, as Hamden said, letting people feel that their lawyer did a good job and that you considered all the angles and that the result was just. And Hamden said every lawyer that practiced in front of you felt like you were their friend, you were helping, you were always very respectful, you were always in good humor. And the other thing he said is that you knew that he needed a colonoscopy, and you told him he was not going to get any more rulings in his favor until he got his damn colonoscopy. Now, I can't imagine any judge that would be that caring and be able to pull that off. But tell us about the Shivo case, because that was, such a worldwide event that landed in your lap due to no fault of yours.
Well, Teresa Marie Schindler, as a teenager, was overweight. And based on the guardian ad litem report of Dr. J. Wolfson, her father used to say some very unkind things about it. And she decided she wanted to not be overweight anymore. And so she dieted and ultimately became bulimic. A fact she never conveyed to her doctor. She married Michael Shivo, and in, I believe, January or February of 1990, at about 5:30 in the morning, she went into cardiac arrest due to a potassium imbalance, which was created by the bulimia. EMS got to her, but not really soon enough. She was still alive, but in what we call a persistent vegetative state. Michael was appointed her guardian, took her to California, seeking treatment. He even went and obtained a nursing degree so he could be more help in taking care of her. He and the parents were on the same page. They lived together to save money. Even encouraged him to date, as I recall the testimony. And several years later, Gary Fox, a lawyer from Miami, and a very good one, got the jury in Pinellas County, and it was Judge Philip Federico Sr. presided over that. And the jury found her 70% at fault for not disclosing to her doctor the bulimia, but it's still, the 30% netted $700,000 for the guardianship and $300,000 for the husband for loss of consortium. He and the parents got into an issue, almost came to blows in her hospital room, over whether or not he had agreed to give them half of his $300,000. They also wanted an additional sum to pay the taxes on that. He said that conversation never took place. They never spoke after that. He ultimately, in 1997, I guess, filed a motion to withdraw life support. Parents opposed it. And it's kind of interesting, when this thing was heating up, Judge Bruce Boyer was handling probate and guardianship in Clearwater. I was out sending bad people to state prison. But I became chairman of the Circuit Judges Conference a year earlier than anticipated. So July 1 of 1999, I came back to probate and guardianship because I could better manage my calendar and still be at the beck and call of the Chief Justice. January of 2000, I tried the Shivo case. All things being equal, I'd have still been a crime, but there I was. The issue was under the statute and case laws, whether or not what are her wishes. She had no living will. She was 25 years old when she went into cardiac arrest. And back then, nobody that age thought about advance directives. And I'm not sure lawyers thought much about them for young people. So the issue, it was a substituted judgment. What would she want? And I found from the evidence that clearly she would not want to be kept alive in that condition. And so the first order, I ordered, or I granted Mr. Shivo's request for him to withdraw life support. He did that. They filed a motion in front of me to stay, and I denied it, and they turned that into a brand new tort lawsuit against him, and they filed it in St. Petersburg. And they had an emergency motion to reinsert the nutrition hydration tube, and that went in front of a duty judge at like 5:30 in the afternoon. I heard about the motion, which was exactly the same thing they tried in front of me. But when I heard which judge it was, I said, well, he has trouble saying no without cameras looking at me. So he granted it. The tube was reinserted the first time. The husband took it up to second district reversed, said, you've got no business doing that, Mr. Duty Judge. Sent it back to me. But they ordered a new trial, not on anything I had had in front of me before, but it was whether or not there was any new treatment that she would elect to take as opposed to having the tube withdrawn. And they, in the order, they did two things. One, they said the parents will select 2 board certified neurologists. The husband shall select 2 board certified neurologists. They will agree on a 5th. And if they can't agree, the court will appoint the 5th. Well, since they couldn't agree that today is Saturday, I started looking, and I ultimately found a doctor at the Cleveland Clinic in Cleveland, Ohio, Dr. Peter Bambakitis. And the second thing they did was, no, don't let the husband withdraw it. Judge, you set the time and date for it. And I wasn't particularly pleased with that. That really wasn't the motion. The motion didn't ask for me to do it. The motion actually asked me to allow him to do it. But anyway, you do what the appellate court says. And we had a second trial. I found from the evidence there really was nothing new. And my first ruling in that case was to define the phrase new medical treatment. And I defined it as any medical treatment she had not undergone. I wasn't interested in some doctor suggesting something that came around 3 years prior, and an argument about whether or not this was new or was it 3 years old. And actually, one of the treatments recommended was hyperbaric, which goes back into the 1800s, I believe. But she never had that. So I heard from the 5 doctors. I ruled that nothing could change her mind. And then I ordered the tube to be withdrawn. It was put back in a second time. The Florida legislature passed a law that allowed Governor Bush to do that. He did that. Went up to the Florida Supreme Court, who ruled that law to be unconstitutional on a 7-0 vote. And 3 of the justices had been appointed by Governor Bush, as a matter of fact. So ultimately, I ruled that the tube would come out on March the 18th of 2005. The federal government filed a motion to intervene and to stay, and an attorney for the House Select Subcommittee on Government Reform argued it. And I was on my way to my undisclosed location because that was the day the tube was to be withdrawn. So I'm in an automobile, not driving, of course, having this hearing. And the argument was this committee has a duty to look at these machines in operation. If it's withdrawn, it won't do them any good. We're going to meet in her room next Friday, which happened to be Good Friday. I didn't ask or get involved in whether or not they had permission to go onto private property, because the hospice in Seminole is private property. Her room is private property. Nobody's got a right to be there. But I didn't go there. But I did ask this question. I said, Counselor, I understand that these are important matters for your subcommittee. Can you share with me how many other site visits the committee currently has scheduled? And I got a pregnant pause from the lawyer. And then he said, none. I said, thank you very much. I said, I'm going to treat the federal government just like I did the state. This is not your issue. Thank you. Motion to intervene denied. Motion to stay denied. And the tube was withdrawn. That was Palm Sunday, Friday. That weekend, Congress got involved in it. And they passed a law that allowed the federal courts to get involved. And then the parent's attorney filed a lawsuit in the United States District Court, Middle District of Florida, Tampa, seeking an injunction. And Judge Whittemore ruled that he had not made out a sufficient probability of prevailing in the end lawsuit, and that's a requirement for a temporary injunction. So he denied the request for the injunction, and she finally passed away on March 31st of 2005.
What kind of pressure did you get? Interpersonally, professionally? That sounds like a very tough experience.
Well, the case itself was not terribly difficult, Alan. There was little or no evidence to support not doing what I did. All the evidence that seemed to indicate she would not want that. And in retrospect, she got in that condition because she wanted to look good. And here she was, poor woman, clenched fists, a hole in her throat from where the respirator had been. It was just sad. I was flown out of the county, my wife and I, twice by the sheriff because said he couldn't protect us. We had 24/7 law enforcement undercover in our condo for 5 or 6 months. One point we had a Marine patrol boat. We live on the water. Marine patrol boat back there. Wore a bulletproof vest unless I was in my condo or in the courthouse. The sheriff in a marked cruiser, actually the bailiff, not the bailiff, would pick me up every morning and bring me home every afternoon. Took me to get a haircut, those kind of things. It was very stressful on my wife. Now, I grew up here. I came to Pinellas County when I was 4, and I've probably known well every chief of police of Clearwater, going back to Willis Booth, and then he left in the early 60s. And I have great confidence in our law enforcement here. I think they do a good job. I was confident that I was going to be just fine. And interestingly enough, the fellow who headed up Clearwater's portion of that is now the chief of police of St. Petersburg, Anthony Holloway, who is a first-class cop in every respect. My church decided that I had done the wrong thing, and a new pastor invited me to leave, which I told him he could. I did not withdraw my membership. I told him he could if he didn't want me in his church anymore, and he did. So it was rather eventful, Alan. My picture was front page New York Times, albeit below the fold. The Tampa Bay Times did a story a couple years ago. Got a call from Mark Douglas on the 10th anniversary of her passing when he was with Channel 8, and I kind of stayed away from the media. I just wasn't into that. But Mark Douglas, to me, was an excellent journalist. He'd done me some favors. I'd done him some favors, all perfectly appropriate, but favors from a time-wise perspective. So when he asked me if he could interview me, I said, of course. So I went out there to their office across from the St. Pete Clearwater Airport on the 31st of March, 2015, and he did an interview.
Yeah. Marcia and I were in Florence, Italy, and the Florence newspaper had your name and picture and Hamden's name on it. I didn't know much about the case. I had to go to Florence, Italy to learn about it. So it was definitely a national thing.
Poor Hamden, he was invited by the ABA to speak in Key West about the Shiloh case. And he asked them, says, would you like me to bring the judge? They said, can you do that? He said, I think so. So he called me, told me it was on a Saturday. This is a couple years ago now, I guess. He said, we need to be at Alfred Whitted Airport at 6 o'clock Saturday morning. He said, I've chartered a plane and a pilot, and we're going to fly to Key West. I said, Hamden, there's no way that I'm going to wake up on Island Estates early enough to be at Alfred Woodard Airport at 6 o'clock. I said, you rented the plane, I'll rent us rooms at the downtown Hilton. So I did. We got 2 rooms down there, and we checked in. Then we went to Ruth Chris for dinner and had their happy hour special. And we were able to get up at a reasonable time and go to the airport, fly to Key West.
Nice. George, before we go to mediation and resolving disputes, do you have any other things that that you'd like to mention before we go to George Greer as a mediator?
You're forgetting my really famous case was the Hulk Hogan divorce. Which is interesting. But they chose to settle rather than have me. I think we had it set for a 3 or 4 week trial in like October of 2010. And a few months prior to that, they reached a settlement agreement.
Which I'm sure you encouraged.
Well, there was a war going on with the lawyers there, very candidly. And I could see it coming. We had lawyers from around the country, around the state. And so the very first hearing I had in that case, I had my JA tell the lawyers, bring your calendars. And so we went out 6 months. And we had a case management schedule each month for 6 months going out. And when we got the first one, we did another one 6 months out. So we always had these lawyers' calendars coordinated in a 6 month time frame. Because we had one from Reno, we had one from Miami, we had several from Tampa, Denicolo from Clearwater. So getting them to agree on setting aside time just wasn't going to work. But the interesting thing, after one case management conference, and they were usually 2 to 4 o'clock in the afternoon, I'm home watching the 6 o'clock news. And this had been recorded because the reporter from this, I guess probably Channel 8, that's what I usually watch the 6 o'clock news on, was interviewing Mrs. Balea's lawyer from Miami. And in the courtroom, this is inside the courtroom, and in the door comes Mr. Balea, Hulk Hogan's lawyer from Reno, fellow named Houston, last name Houston. They started shouting at one another. And of course, the camera keeps running. This is good stuff, right? Then they get into chest bumping, and the camera is still going. I am absolutely aghast. I really had 3 choices. Actually, I had a few more than that, but the 3 that immediately came to mind, I could have removed the fellow from Reno, his ability to practice law, in this case in Florida, because he was not a licensed Florida lawyer. And there is a provision to allow that on a limited basis. I could have gotten a tape from the station, sent it to the Florida bar, or I could have done exactly what I did do. The next case management conference, everybody's in the courtroom. TV cameras are in there. People are in there. I asked the bailiff to bring the lawyers into my chambers. So they came in, and it turned out there were two men, 2 women. I'm not sure how they were paired up, but I said, this is for the men lawyers only. And I absolutely ate their lunch. And I basically said, if I see anything close to that again, you will learn to love bologna sandwiches, because you will have them at taxpayers' expense for 5 months and 29 days. And the lawyer from Miami apologized, to his credit. And I said, apology accepted. And we got up to go into the courtroom. Same lawyer said, Judge, thank you for doing that in here. I said, this is an issue between us. This is not a public issue. So that's why it's in here. And so we went back out and had our hearing. I had a few that they had some issues after the settlement was signed that I had to decide and rule on. It was a confidential settlement agreement, but I was told several years later somebody just attached it to a motion and made it real public. So
So George, let's go to disputes, because then with all your experience, first as a lawyer for decades, then a judge, then a mediator, what's your advice when a dispute starts?
Well, I guess the real advice is see if you could resolve it. Obviously, there was a reason you got into this issue. Don't know, whatever the issue is, it was a relationship of some sort. And I guess my real advice is to see if you can resolve it. The advice prior to a dispute arising, candidly, is to get it in writing, which frankly, a written contract, the one thing it will always do is keep honest people's memories intact. And the example that I use, and I'll bring Alan into this mix, Alan Gassman is as ethical and honest and honorable a person as you will find. I like to think I'm close to that. He and I today could shake hands on a very involved matter. I promise you, a year from today, we will not remember it the same. So that's why you put it in writing. If you're dealing with a crook, it doesn't matter if it's in writing or not. They're going to try and beat you out of it anyway. But a written document is invaluable. It's always best to have a lawyer do it, because a lawyer will know things that a lay person will not think of. But when the dispute arises, it's best to go to your adversary and just see if you can work it out. It's cheaper, it's quicker, and probably a better resolution than you're going to get either in mediation or trial.
Okay. And how do you know if you're going to get in bed with a liar? Or you do?
You're not, probably, or you wouldn't get in bed with them. But you know, it's interesting. You and I have been around for a while, and there's some names that we could start throwing back and forth to each other that we would not in any way advise a client to get to a transaction with. And yet people still do. People who are smart do that. And same thing happens. And I'm not going to slander anybody on this webinar, but you know, a con man is a con man because he or she can talk and persuade, and it happens.
Yeah. What about in the marital world? Because you were obviously a divorce judge for a long time. What happens before the couple came to blows or needed to see a mediation that maybe you would? What do you see over and over again?
Well, what I see over and over again is one of the two usually is aggrieved. Somebody has had an affair, somebody wants out, and so there is a desire to punish. And what I try to do in family law mediations is to talk to them about business decisions. You need to approach this like it's a business deal. Would you pay $10 to have a chance of gaining $5? The answer, of course, is no. But they will get bogged down. Alan, you've never had the pleasure of being divorced as I have. Thank goodness. Smart man. Wonderful wife. But they get bogged down in little things to punish. They know that the other spouse loves the dog, so all of a sudden the dog is the issue. Or the other spouse thinks, Mom, you know, this bedroom set is great. And it just gets bogged down. Now, judges will never get involved in sorting out what we call pots and pans. Judges in family law trials will not, I've never seen them do it. what they will do is tell the parties to create what we call A and B lists. One of them creates 2 lists of the personal property, the furniture, the pots and the pans and the silverware and that kind of stuff. 2 lists. And the other side gets to pick which list they want. And that generally works. It's kind of like if Alan and I jointly did something and $100,000 in cash on the table, and we're arguing about how to divide it. Well, I'll divide it into 2 stacks, and I'm gonna make darn sure they're even. And then Alan gets to pick which stack he wants. So we each get $50,000. I know you're cutting your fees, Alan, but I'm just using that as an example. But family is tough, and actually, probate has similar issues where it gets real personal, because siblings fighting over mom and dad's money is not much different emotionally from spouses fighting over their own.
And what can an estate planner do to try to resolve that before it happens?
Well, I think an estate planner can probably encourage his or her clients to have conversations with the heirs, to where they know up front it's not a surprise. Dad says, I'm leaving my estate to your sister, Johnny, because you have a nice career and she's a school teacher. Whereas if Johnny finds out after Dad dies that he's been disinherited, he's going to blame Sis for doing something wrong. And that relationship will become estranged. So knowledge is wonderful in those areas of estate planning, but just advise. And if you've got an estranged child, send them an email or send them a letter. Let them know that you're doing it.
Maybe see a neurologist the day you do it.
Well,
make sure you got your marbles.
I haven't done that. So we lawyers oftentimes give advice that we don't follow ourselves, but I still think that's probably a good idea.
George, every once in a while, you see a litigation situation that I think, as you alluded to, is a problem because the lawyers are the problem. You get macho lawyers who push emotional buttons and cash in on it. How do you disarm that as a mediator when it's the lawyers who pick you? How do you do that? How do you get the message to the client that the lawyer's maybe not given the whole picture?
That's easy to accomplish, like it's easy for me to dunk a basketball. You can't. I mean, it's the lawyers that select you. It's the lawyers that are responsible for you making money. And my own personal belief, a lot of times you can settle cases by discussing the cost of going forward. But unless the lawyer brings it up, I don't bring it up. I'm not going to tell the client that your lawyer, unless he settles this case for you, is going to make a lot of money and it's going to cost you and you're not going to be happy at the end. Because I'm dead in the water with this lawyer if I do that. So you're trying to get people to the table. Lots of times the lawyer's problem is that they perhaps misunderstand things. They're not as well versed in this area of the law as they might otherwise be. My way of handling that is, I think Judge St. Arnold is going to have a real problem getting his arms around that theory. And that's about as far as I go, but I subtly let everybody know that it may sound good, but it's probably not going to have a good result.
George, I'm speaking at the Notre Dame Institute in October, on how to fire a client, when to fire a client, and it's an ethical talk. What's your experience seeing lawyers representing clients that they should have fired? Or what's your advice to lawyers and CPAs watching you right now when you have clients, and you are in the practice of law, you know what it's like. You have a client, they seem nice. Sometimes they're not so nice, then they're nice, then they're not so nice. And then it turns into a catastrophe.
Well, the first marker to fire a client is when they disregard your advice. And if they're not going to follow your advice, they're not going to be happy at the end of the day anyway. So it's probably a good time for the lawyer to suggest that the client find a lawyer whose advice they will follow. If they're doing something inappropriate, you don't want to get in front of the court as a lawyer and have the court decide your client, while you're representing this client, is doing bad stuff. So it rubs off on you. So if they're doing bad things, inappropriate things, I mean, if they're stalking their spouse in a divorce case, you really want to get away from that, because that can hurt you as a lawyer. And all lawyers got this reputation. Abe Lincoln's correct on that. But you know, too many lawyers, we have too many lawyers out. We have too many law schools, and too many lawyers just set up shop because they got student loans to pay, and they don't have good mentoring in a law firm. And so they don't really know what they should do in those things. And they may need the money that's coming in monthly from this client, which is never a good way to decide if you should stay in a case. But that happens. And we just need more mentoring. I'm a firm believer that law school and undergraduate school ought to be 7 years, but the 7th year ought to be working for free in a law firm. Because all law school does is teach you how to pass the bar exam. It doesn't teach you where the courthouse is or what you do when you get there.
No, you're absolutely right. That would be the most worthwhile thing you could do for a young lawyer would be to have them work for like medical residencies, because the young lawyer would make so much more money over their career if they had a year of careful mentoring.
Plus, they'd be a much better lawyer.
They'd be a much better lawyer. They'd have a lot more fulfillment.
Yeah, the chances of them getting in trouble with the bar would be greatly reduced.
Yeah. So next Tuesday night at 6 p.m., I speak to my Stetson course I'm teaching on law office management and professional mastery. So
what do you find time to practice, Alan?
What's that?
When do you find time to practice? You're doing Notre Dame, you're doing Stetson, you're doing this.
There's time. So
okay.
What do you say to these second and third year law students when you're teaching them law office management and professional mastery?
I've never done that. So as you well know, the best thing you can have in a law office is a good legal assistant. They're absolutely invaluable. But how do you know that they're a good legal assistant if you don't have the mentoring? And I'm sure everybody at Stetson that you're talking to wants to go to work for a law firm because they don't have overhead expenses. They've got student loans they're dealing with. And hopefully they understand that this is the best way they're going to learn how to practice law. But unfortunately, there are not that many jobs out there. And the cream jobs, when you and I were young lawyers, Alan, were working for the state or the PD, because you got trial experience, you got to know the defense lawyers, and it was a good way to start your law practice. But if a kid's coming out of Stetson with $100,000 in student loans or $150,000, working for a state like that it just doesn't work. I think you can get some deferment on it, but it still doesn't get it paid.
Yeah, I think the best strategy is to find a small or middle-sized firm or any firm you can get into to learn our bad habits before you go out on your own and start your own bad habits.
Well, and the older lawyers just have invaluable information for you. And back when I started, Clearwater was relatively small compared to what it is now, but you basically knew every lawyer in town, and you had a list of, if I got this question, here's what I'm going to call. And Senior Judge Bill Castagna, who just passed, and you knew him well. Bill was actually introduced me to my investiture in 1993, but he was my go-to guy on ethics. And if I had a question, I would call him. And in the inside of the file, I'd write that I called him on this date, and this is what he told me. Now, doesn't make it bulletproof, but in my humble opinion, that would go a long way if he happened to be wrong and the bar doing anything.
Yeah, it always is good to check with another lawyer if you're a lawyer having an issue. George, you mentioned, of course, you weren't driving. Now, I just had retina surgery Friday at Baskin Palmer in Naples, and it came out pretty good. But your vision has not been perfect. They say justice is blind. Do you have any comments on whether justice is blind?
Well, the whole point of justice being blind is kind of like judicial independence. You got to understand what that means. Judicial independence, people say, well, you can't be independent. Everybody's got to be accountable. Well, that's not what it means. What it means is that judges should be independent in their decision-making process. That's what it really means. Justice is blind just simply means because you are Alan Gassman, that doesn't give you a leg up or a leg down, whether you're black, white, yellow, or brown. And that's what that means. I have pale optic nerve endings. It's a genetic thing. And they just don't work as good as yours works. So.
It's certainly not slowed you down whatsoever.
I try not to.
So then Marcia and I saw you at a happy hour, and you said, "Don't speak in anger." I think that's what you said. Don't speak in anger.
Well, if you knew me well when I was on the bench, if I ever started talking this way, you know I'm ticked off. Because when I got mad when something happened, I wanted to make very certain that every word I said was okay. Because when you get mad, you just fire. You know, you draw, fire, and aim. And you really shouldn't. If you're angry, you shouldn't make decisions in anger. I think that's a good rule. But judges, because usually there's a court reporter and everything's taken down, you don't want to say anything that's going to come back and bite you. So if you ever heard my speech slow down and become very deliberate, you would know that I am not pleased with what's going on at the moment.
You know, I think it's good advice for anybody not to speak in anger unless you've carefully rehearsed exactly what you're going to say, that the anger finally gives you the courage to say it. Otherwise, you could just get yourself in big trouble.
Especially in a marital relationship.
Right. So let me see if I have any questions for you, George, here from the audience. And we have a few hundred people here. Done a great job. Any other good lessons on keeping my marriage together?
Yes. My wife and I, we just hit 37, and she'd been divorced 20 years, and I've been divorced 10 when we got married. And I won't go into why we got married. She wasn't pregnant. Whenever we do get upset with the other, we just walk out of the room. because that great 20th century philosopher Cher said it this way: if I could turn back time, if I could find a way, I'd take back those words that hurt you and you'd stay. So you can't take back words. They sting, they smart, so that's what I say. If I get mad at my wife, I'll just go to another room or go outside, take the dog for a walk. It wears off and then it's over and then you're okay.
Yeah. That's
And
very good.
as a lawyer, don't get angry with a judge, because that's usually counterproductive. You know?
Any advice for young judges?
Yeah. Rule. Young trial judge's job is to make a decision. The appellate judge's job is to take up to 2 years if they want, with all the staff money can buy, and decide if it's a good decision. But lawyers need a decision. And right, wrong, or indifferent, once they get a decision, then they can decide what to do. In the first case I ever took under advisement, I sat on it for 4 months. And I knew what I wanted to do, I just wasn't sure I was going to get there. But before the ink dried on the judgment, I said, this will never happen again. This is wrong, it's bad. And so every time I had a trial and I took it under advisement, I'd reach for the Post-it and I'd write due by, and it was never more than 2 weeks. And I put that on top of the file. And I tell the parties, I said, I will rule by X. I said, I do that for 2 reasons. One's to keep me on track. The other's to keep you from bugging your lawyers. Trust me, if they get a ruling before that day, they'll call you. So don't bug your lawyers. And I think twice in 18 years, I was on the bench. I had to have my judicial assistant call and say, the judge needs a couple more days on this. Are we okay with that? And of course they are okay. But we hear war stories, Alan. You've heard them. I've heard them as recently as Thursday about judges just sitting on stuff, sometimes for years. And there's no way in the world, a year from today, no matter how good a set of notes I take, am I really going to remember?
Yeah. Yeah. So George, I'm getting a lot of good feedback. I'll mention a lot of people are asking, am I going to post this to YouTube? And yeah, it'll be on YouTube in about 3 hours, and everybody will get an email that you can click or forward it to whoever you'd like to forward it to. And then Hamden's enjoying this, and so George,
I need to hear what he had to say.
I know we'll bring him on. We'll bring him back on sometime. Or Hamden, if you want to call my cell phone. But George, you heckled Hamden into getting a colonoscopy. And whenever my younger partners would go see you to get an order for the probate court, you'd say, where's Alan? Alan needs to come here. Is there any other good heckling you did? Because you never offended anyone, but you did heckle them.
You know, the truth of the matter is, Alan, I don't know if I'd have followed through with Hamden had he not gotten a colonoscopy. Because we talked about it several times and he kept kicking the can down the road before I actually said what I said. But I did in fact say it. I thought timely wise, that was the nudge he might need. And it turned out it was in fact the nudge he needed. And I was happy about that. Because you can take colon cancer off the table. And to not do so is just tragic, can be tragic.
Yeah. But anyone else you heckled in any particular ways?
Well, I never saw you in court, really. I saw you in my.
I never went there. I was afraid of it.
Did you ever see Henry anymore? I haven't seen him in years.
Haven't seen him in years. Thankful he introduced me to you.
That was good. He was a good person. He got his MBA from NYU, I remember.
Yep. Yep. So George, any final words? I'm going to try to play the Hamden tape. It might work. It may not work this time, but you've had a really good audience, that everybody's really enjoyed this, and you've been a good friend to thousands and thousands of people. People always come to me, I had George Greer for my divorce. He was fantastic. I didn't like my lawyer, but I like Judge Greer. So,
But I got my haircut yesterday, and a gal in another chair said, "You were my mediator 5 years ago. You did a great job." It's funny though, if I'm in public and somebody comes up and says, "You are my divorce lawyer," and they say it kind of like that, I just look at it and say, "How'd I do?" Because
very good.
in a divorce, if anybody's happy, you probably did not do a good job. Because in those cases, both sides have unrealistic expectations, and it's not good for the system or for them to have a winner. It's much better when everybody has a piece of the loss and then moves on. But and it's not that you try and do it that way, but somebody wants X and the other person wants half of X. Well, sometimes you give them what they want, but when you analyze everything and come up with a decision, you're not looking to cut the baby in half. But oftentimes you do, just because of the unrealistic requests of both sides.
Yeah. Complicated stuff too. It gets very complicated and no one understands it. That doesn't help either. And then the law is way too unclear in that area too.
Well, it has to be, because no one size fits everybody when it comes to that. And then you have, we got a lot of CPAs, you said. Well, I'm sure some of them are forensic CPAs.
Yeah.
And they play a huge role these days in dissolution cases. And as a mediator, I rely on them. Most of them I've gotten to know, at least in this part of the world. And you can ask them questions, and they'll just plug it in and say, here, if this goes away, here's the result. But they're very good.
Yeah. All right, George. Well, we'll have you back for sure. I'm getting a lot of good questions and a lot of good feedback. Really appreciate you joining us.
Well, this came as a result of happy hour. That's the other thing you didn't mention. Happy hour.
Yeah, Marcia and I ran into George a few weeks ago at a happy hour, and it was a very, very nice event. It's always a great time being with you. We'll have to go out to dinner with Hamden.
Yeah, we will.
With our wives.
Because we owe Hamden. So we can, buying for 6 and much worse than buying for 4. So we can certainly make that happen.
Yeah. And I'm not sure when his next colonoscopy needs to be, but we can put that on the calendar too and make sure he gets it.
Well, our gastro guy, I just filled out when I was waiting to come on here. I'm going Tuesday for my new gastro guy because Dr. Weston retired.
Yeah, Rick Weston, great gastroenterologist.
Yeah.
Well, it's a great note to end a webinar talking about going to your gastroenterologist.
Well, but it's important. Here, to me, the two really important physicians, especially here, are the gastro, but the dermatologist.
Yeah. Yeah, those of us who grew up in Florida need to see a dermatologist at least once a year, head to toe, and those of you who are lying in the sun getting great suntans, you may just be killing yourself. People don't realize that. You make a very good point.
Well, I was not a sun worshiper on the beach, but growing up, you're outdoors all the time. I grew up in Dunedin when it was small, and all we really had were orange groves and Grant Field, the ballpark. And that's where the kids would congregate. And we'd either play football or baseball or do something, but it was outdoors. And so you don't really realize that. So my dermatologist has cut my forehead several times. He's a good one.
Yeah. All right, George, any final words here?
No, just have a great weekend, Alan, and give your bride a big hug and kiss from me, for me.
You do the same for me. Always a pleasure.
And let's both of us hammer Hamden about dinner.
Absolutely.
Okay.
Oh, that's right. I forgot. We could make him pay too.
No, he represented my wife in a matter that just got a big burden off her back.
No,
So
he's pretty wonderful about that.
I told him we're gonna buy you dinner. Besides you getting paid, we're gonna buy you dinner.
So
that's
Brittany, can you try the video again? Okay, so we're gonna play this. We're gonna play Hamden's video, and those
okay.
of you who can read lips, you'll definitely. There we go. Nope.
No audio.
Yeah, no audio. Well, we apologize for that.
I can remember when he had dark hair.
Yeah. What we'll do is we'll send his testimonial out to everybody separately.
Okay.
I apologize to Hamden because it was great, but we'll do again.
Okay. Sounds like
All
a
right.
good.
Have a great.
Have a great weekend.
All right. You too, and to everybody else. Thank you.
So long.